Hey everybody, I'm Mike with Budget Guns and Gear Reviews, and this is The Right of the People, where we use the first to defend the second every Friday night at 7 p.m. Eastern. So uncover your keyboards and fire up your fingers. It's time to join the conversation.
Hey everybody, I'm Mike. This is MK Outdoor Journal, but this is The Right of the People. I know it's not 7 p.m., it's 7:05. We're running a little bit late tonight. I wanted to give, matter of fact, honestly, I spent too long at Circle K trying to get the ye old Polar Pop, and I didn't get the show set up until 6:31. So in order to make sure that everybody got the notification a half hour beforehand, I set the show to start at 7:05. But hey, better late than never. We are here. Speaking of here, I would like to welcome my wonderful esteemed panel. We have the one, the only, the sourpuss himself, he who is trapped behind enemy lines, Calaveras 32 Special. How are you, sir?
I'm doing just fine, Budget. I appreciate the invite.
Hey, no problem. You are always welcome. Speaking of always welcome, we got the rowdy one, the roll call 219. How are you, sir?
Hey, thanks for having me. I can't wait for the show.
Thank you for stopping by. And then we have the irascible and harassable, yet lovable, Squibload.
Yeah, thanks for calling on me last. That gave me enough time to get out of the loud factory and come up into the empty offices where it is nice and quiet.
Awesome. Woohoo! Speaking of awesome and woohoo, we got everybody out there in the chat tonight. We got Jason Stewart showing up, New York Outcast, who was indeed the first to say first. Gizzard Gary, what is this? We got Seven out there, Seven Wonders. Hello to everybody else. If you're out there and you haven't sounded off in the chat, say hi. I'll say hi back. If you have an opinion, if you have a comment, if you have something you would like to share, please feel free. That's one of the things I love about this format, is that it is a conversation not just between me and my guests on the panel, but between us and you as well. Remember, having a two-way exchange of ideas is how we take out our own, take a look at them, compare them to someone else's, and see if there's something we need to change. That's how we grow. I welcome it, even if you disagree with me, especially if you disagree with me. But just don't be a dick. You know? If you are, my mods or myself will, well, take care of the problem. So, other than that, feel free to say whatever you want. Let's see who else is out there. Small caliber arms review. If you can't get her on time, get here when you can. Yeah, pretty much. Jacob S. is here. Yo, driving, can't talk much right now. Well, be safe, Jason, or Jacob. So, hello to everybody. We got some stuff happening this week, or more importantly, we got some stuff happening next week. Earlier this week, there were some hearings about what's going to happen during the Kyle Rittenhouse trial. That's a case we've been following for a long time, since it happened. For those of you who somehow aren't familiar with it, the Kyle Rittenhouse case is the case of the young man who was in Kenosha, Wisconsin. During the riots up there, he was guarding a business, and he was a 17-year-old at the time, and he was carrying an AR-15. He ended up shooting 3 people, killing 2 and disarming 1. Well, if you call blowing a softball-sized chunk out of the guy's bicep disarming. There was one guy who was really lucky. The fellow in the white pants that jumped in and tried to kick Kyle in the head when he was down, got shot at 2 rounds, but Kyle missed, turning the fellow's white pants into brown pants, or at least with a brown stripe. Anyhow, subsequently, Kyle was, after trying to surrender to the police on the scene, after he ran from the angry mob chanting and yelling to get him and kill him and all that, after he ran away from them, he tried to surrender to police, but they let him go, told him to get out of the road, and went on about their business. He went back home to Illinois and is now on trial in Wisconsin for murder. I've went over this video. It's a clear-cut case of self-defense. As a matter of fact, I think maybe this weekend I'm going to go ahead and do another overview. I did an overview of it live a long time ago. I think I might do just a produced video, an overview of it, just to kind of refresh everybody's memory. So look for that this week. Not this week, but this weekend. Anyhow, there were motions and there was a hearing to talk about what's going to be allowed to be said, what's going to be allowed evidence-wise in the case. So let's go ahead and take a look at that. This is from ABC7Chicago.com. Kyle Rittenhouse trial. Wisconsin judge sets ground rules on evidence. Use of force experts. This is from October 25th. Kenosha, Wisconsin. A Wisconsin judge laid out the final ground rules Monday on what evidence will be allowed when Kyle Rittenhouse goes on trial next week for shooting 3 people during a protest against police brutality, ruling he'll permit testimony from the defense's use of force expert and on how police welcomed Rittenhouse and others carrying guns during the demonstration. Well, you can already tell what ABC7 Chicago's slant on this is. Rittenhouse sat silently in the courtroom as his defense team and prosecutors argued the last-minute motions. What both sets of lawyers can and can't say in the course of the trial was the subject of intense debate. The 18-year-old is charged with killing 2 men and seriously injuring another during sometimes violent protests in Kenosha after the Jacob Blake police shooting in August 2020. The then 17-year-old patrolled the streets with an AR-15 type of weapon. If more than one of them were engaged in arson, rioting, looting, I'm not going to tell the defense you can't call them that, the judge said. The judge also ruled that the 2 deceased men and the injured man could not be referred to as victims. The word victim is a loaded word, he said. Alleged victim is a cousin to it. Rittenhouse's attorneys want use of force expert John Black to testify that Rittenhouse acted in self-defense. Prosecutors have asked Judge Bruce Schroeder to block Black's testimony, arguing that jurors don't need an expert to understand what happened that night. Schroeder told the attorneys that Black wouldn't be allowed to testify about what Rittenhouse was thinking when he pulled the trigger or whether he definitively acted in self-defense. I almost certainly am not going to permit an opinion from anybody on the ultimate facts of the case, he said. Assistant District Attorney Thomas Binger said if Schroeder allowed Black to testify only about the timeline of events that night, he wouldn't call his own expert to the stand. Defense attorney Mark Richards agreed to the deal. Binger asked Schroeder to bar a video that shows police telling Rittenhouse and other armed militia members on the street that they appreciated their presence and tossing Rittenhouse a bottle of water. The prosecutor said the video would transform the trial into a referendum on police procedure that night when it isn't relevant. This is a case about what the defendant did that night, Binger said. I'm concerned this will be turned into a trial about what law enforcement did or didn't do that night. Defense attorney Corey Chirafisi argued the video shows that police felt Rittenhouse wasn't acting recklessly. Binger countered that the shootings happened after Rittenhouse interacted with the police, but Schroeder decided to allow the video. If the jury is being told, if the defendant is walking down the sidewalk and doing what he claims he was hired to do and police say, good thing you're here, is that something influencing the defendant and emboldening him in his behavior? That would be an argument for relevance, the judge said. Jury selection begins 1 week from today, and the trial is expected to last at least 2 weeks.
The moment you are...
So, trial begins Monday for Kyle Rittenhouse. Now, I don't know whether that's jury selection or arguments or any of that, but I can tell you this, the media is going to have a field day with dredging this. I mean, well, hell, I guess I'm part of the media and I'm having a field day already, but this is going to be an interesting one to follow. This has so many implications on self-defense and, regardless of whether or not he was supposed to be there, regardless of whether or not he was supposed to have that rifle, he was there, he did have that rifle. Were his actions self-defense? Now, again, as I've said many, many times, I'm not a lawyer. I'm just a fat loudmouth with a camera and a microphone. But based on my understanding of self-defense law, based on my eyes and the videos that I've watched extensively, frame by frame, I can't see any way in hell a jury cannot find that the shooting of those three persons was self-defense. I don't know. I think this is going to be interesting drama to watch unfold. Hopefully this will be broadcast somewhere live so that we can watch it. That would be great. I know I will, if that's the case. What do you guys think about this? I know we've talked about the Rittenhouse case over and over, but I find it interesting that the people Kyle shot are not allowed to be called victims. I find that very interesting, because normally the decedent in a murder trial is called the victim. So, what do you guys think about that particular piece of information?
Well, that's true. It's not specific to this case. From what I was reading a different article, and they're saying that is a standard that this court and that particular judge uses. Very true. On pretty much all cases. So it's not that he's trying to help or hurt Rittenhouse on this. That so want to make that open to the public as information as well. And I know on the other article I was reading, they were also arguing about that if Rittenhouse didn't actually see them burning, then they could they call them arsonists in the trial? Yes. And a few other because he didn't witness them committing such and such crimes. They couldn't call the attackers those terms in the trial. Which, if you're not going to allow them to be called, if you don't allow the term victim to be used in a court in general, if you want to be a stickler about it, okay, maybe we don't call these guys arsonists and whatever else.
But the judge ruled that they could.
Yes, they could. He did. But what I was getting to is maybe, all right, well, the judges, the lawyers want to argue about that. How about we bring up the attackers, criminal history that is court record, and that as such it should is public information. So we can okay, well, maybe
what criminal history? You mean where Joseph D. Rosenbaum was a convicted child molester? That was the first guy that he shot, the short little sawed-off, shoot me, that dude who chased Kyle across the parking lot after throwing something in a bag at him. Or maybe are we talking about Gage Grosskreutz, the fellow that was disarmed, who was a convicted felon with a Glock 26 in his hand? That nobody seems to be mentioning this.
Point I'm making, that's where if the lawyers want to get into the minutia about, well, we didn't see him, we didn't see them commit these crimes, but okay, fine, that's where these other crimes have been adjudicated and they've been convicted, and it's court record. So even if they weren't necessarily burning buildings that night, we can show that they have a propensity of committing violent acts. And we, so the theory that they were coming after Rittenhouse with violent intent is not so much of a stretch.
Oh, absolutely right. Although the defense the prosecution will argue that Kyle could not have in any way known that, so that it has no bearing upon his mental state at the time.
And it doesn't, but that's where, because he wouldn't have known their criminal history. More what I was getting to is, if they've done these things before, there was a strong chance that they were physically trying to assault him, because they've already shown that they don't mind, committing physical acts of violence against people, So it's not that much of a stretch to believe that they were trying to commit acts of violence against Rittenhouse.
Now, one thing I would be introducing into evidence is the actions of the decedents from earlier in the night, where the incident that I referenced earlier, the shoot me incident at the gas station that Rosenbaum was doing, and the fact that Anthony Huber, skateboard guy, who was the second individual that he killed, were both there during that confrontation, and their actions there. I think that would be relevant to the to the defense. Now, I've been watching a lot of videos lately from Andrew Bronca from who wrote The Law of Self-Defense. He's a self-defense attorney, and he thinks that there's really no way that if they follow the law, there's no way that Rittenhouse can be convicted. If you guys want to understand why he says that, he's basically like, listen, read my damn book, and you'll see exactly why. And I agree. Having read the book several times, The Law of Self-Defense, it puts out the 5 things that you have to do to meet the criteria of self-defense to be able to even claim self-defense. And I'll probably do that this weekend. Go through this video and show boom, 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 exactly how Rittenhouse does meet that. If you want to take a look at the book, I put the link to it out in the chat. Go ahead and check that out. I highly recommend anybody who is going to carry a gun for self-defense to read that book. Man, who's unmuted? Because I'm hearing a bad feedback loop from somebody.
That was probably me. I was waiting for you to stop so I could say something.
Okay. Go ahead. I have stopped my gob.
That's where I know earlier in the night before, I think it was earlier in that night, Rittenhouse used a fire extinguisher to put out a fire that was on, dumpster fire, quite literally, that was being pushed towards a gas station. Were any of the people that attacked him later that night involved in said situation, or do we know?
From my understanding, the Rosenbaum
was trying to push I watched it live. He was trying to push the dumpster that was on fire, to separate themselves from the situation. And that's when you can see Kyle, as they're talking to somebody else that's around there, you can see Kyle run, grab the fire extinguisher from the gas station, and he runs back across to put the fire out in the dumpster.
And that's why Rosenbaum started chasing after him.
Yeah, I was going to say, if Rosenbaum recognized Kyle, that could have influenced what happened later.
Let's go out to the chat. Let's see. Jason Stewart disarmed, literally. New York Outcast says they had it coming. Seven says, yeah, I think Kyle did a great job. Had I been in this situation, I definitely would have nailed the guy in the white pants. Squib would have done the same thing as Kyle, but with his bare hands. Seven says Kyle should not have been charged. Jason says the left will have Kyle convicted. Facts or law doesn't matter to them. Also, looking at my watch, if you don't prosecute that kid, you're not getting $1 billion. Evening, MK Joe. How are you? So there we are, caught up in El Chatteroo. Oh, thank you to my hater for that thumbs down. I appreciate it. Awesome. Thank you for the engagement, dude. Got 4 thumbs up. Them some rookie numbers there, fellas. We got to get those numbers up. But anyhow, I think that this case is going to be interesting, and it's going to have a lot of impact on self-defense. Because it sets, I think, the precedent of whether or not politically charged prosecution can be and will be and should be successful in this country. Because, as I think all of us here in the chat have talked about before, that this is a political prosecution. It's so that our lords and masters can prevent anyone from defending themselves against the mob. It's the same thing as what happened with the St. Louis couple. They dared to step out of their castle and defend it against the ravening horde that was going past, and they started to pay the price for it. Well, Kyle happened to have been forced to kill 2 people and grievously wound another. they definitely want to make a martyr out of him. They definitely want, well, not a martyr. They want to make an example out of him. They want to nail his hide to the barn. And I'm hoping that the justice system doesn't allow that. Because, again, I've watched every speck of video that I could get my hands on with this, and I don't think this kid's guilty of murder. I think he acted in pure self-defense. So we'll see what happens in the upcoming weeks, that's for sure.
Does anybody know if he's going to testify or if his lawyers have invoked the Fifth? Or
I don't know. I don't know if he's going to testify or not.
I think his behavior during this, if he does testify, or his behavior after this, no matter what the outcome is, could be a good thing or a bad thing for the Second Amendment culture. And so far, the things I've heard about haven't necessarily represented the same people that have stood behind this guy, stood up for him on social media. I guess like so many other things, it's going to be a wait and see. Let's just see what he does. If he wins and he turns into a total, tool over this, that's not going to help. That's not going to. And I don't know if anybody's approached.
Let's talk about that.
Well, has anybody approached him about that, or has he just been approached by sponsors and other douchebags out there, the kind of people that Roe was talking about in Rants and Raves this week?
Well, I don't know if everybody out there knows this, but after this, Kyle's been out on bond and he's done some sketchy ass shit. He's been hanging out, at least in one occasion, hanging out in a bar, which is absolutely legal for him to be there at 18 in his home state. But he's been hanging out with people that, whether you believe, what's been said about them or not, I hate to use the phrase, but the optics don't look good. Hanging out in a bar with the Proud Boys when you're being accused of murdering people in a racially charged riot, whether or not the Proud Boys are racist, and which I don't believe they are, is irrelevant. The fact is, it don't look good. Even hanging out in a damn bar and having fun, when your ass is about to be on trial for murder, it don't look good. So, I think that kind of thing is definitely going to harm him because, let's face it, they're never, ever, ever in any way, shape, or form going to find a jury that says, Kyle Rittenhouse? Who's that? I've never heard of him. That's not going to happen. Every single person they have as a juror will have heard the name Kyle Rittenhouse, will know something about it. Unless they deep dive into things like we do, all they're going to hear is what the mainstream media has spun about the kid. Oh, he wasn't supposed to be there. He shouldn't have had that rifle. He had that rifle illegally. Oh, that means you can't shoot nobody in self-defense. What? He's hanging out in bars with racist Proud Boys. Oh no. That's all that they're going to have heard. So I think that the jury in this is really going to be the wild card factor. The law is on the kid's side. I think that in the situation, he did the right thing. That night, he had no other choice, given the facts that surrounded it, given the context, the fact that he was there, since he did have that rifle, since Rosenbaum tried to take it from him, since an angry mob was chasing him and assaulting him, even using deadly force with that skateboard blow to the back of the head, and the dude in the white pants trying to kick him in the head, and Gage Grosskreutz having a firearm and pointing it at him, Kyle acted appropriately. In those circumstances, I would have done the same thing. But his behavior after that, I think, is going to taint and prejudice the jury against him. What do you guys think on that?
This guy could turn out to be the face of 2A for a short time, and it could hurt us, or it could help us. It could strengthen the whole self-defense thing that people just don't seem to understand, especially if there's a legal precedent set. But depending on how he behaves during and after, could be a black eye on the culture.
Clover Tech says, I think you would be really surprised at the number of people who have no clue who this kid is. You give the general populace way too much credit. I see what you're saying, and throughout the rest of America, I would agree. Do you really think there's 12 people in Kenosha, Wisconsin who have no idea who Kyle Rittenhouse is? Says also his lawyers will have a chance to get rid of those who seem biased during selection. Otherwise, he is a sucky lawyer, which could be. Yeah, you're right. During the jury selection process, they can disqualify jurors, but still, it's going to be difficult to, you know, I think the juror that's like, yeah, I know about this. Yeah, I want to put this kid away. Rittenhouse who? I never heard of her. You know, who thinks one thing and says another. That's going to be the wild card. But again, I think this is going to be some interesting legal drama to watch it unfold and to see how it impacts the Second Amendment and self-defense law throughout the country. Because I think it will have some impact. What and how much, I don't know, but it will have some sort of impact on that. So let's keep our eyes peeled and watch and see what happens.
Yeah, like I said on my show the other night on Wednesday, you know, there's a ton of different cases that are coming about that have to deal with the Second Amendment. Mm-hmm. The letter I got from the Second Amendment Foundation about their cauldron is dry is concerning. We are eclipsing some of the greatest wins that we've seen in quite some time with constitutional carry going wild in states, and we're winning cases, and you know they're still toying around with the bump stock thing, but this is a real big precedent, I believe, because if this kid loses, then that's going to slow the momentum. It's not going to kill the Second Amendment by any means, but it's going to slow the momentum. It's going to slow people that want to open carry in their neighborhood, if need be, if this stuff strikes up again years down the road. Again, this is going to have a pretty good effect on it, because CNN was talking about it last night, and they were talking about Kreitzer because no one's heard from him since the trial, the pretrial thing with the judge about calling people whatever kind of status they want to call them. CNN's on this story, Don Lemon's on this story, and of course Chris Cuomo is. So this is going to make national news. So that's if it never made national news to the certain extent, where you know these big fake media sources are coming out with this story, then I would shy away from it. But since they're running it, and this is the second time I've seen them run it, and then talking about some of the people that they're trying to get to testify, which is Kreitzer, because he's the only one that survived the assault on Kyle Rittenhouse. You know, I mean, we just gotta keep our eyes peeled. We gotta start looking at this. The Supreme Court's going to be looking at stuff here soon. So the Second Amendment is going to be put on the spotlight
next week
here shortly.
Yeah, the Supreme Court is set to look at a case next week, I think, which we're going to talk about that later this evening. And you're right, constitutional carry is on the march. As a matter of fact, we're going to talk about here in a minute, constitutional carry is on the march here in Ohio too. So yeah, I think this case is going to be. It's come at an interesting time in history, and it's definitely going to be something that we want to watch unfold. I do anyway. I don't know, but then I'm interested in stuff like this completely. Moving on, actually kind of moving backwards. Last week, we talked about the Rust movie set shooting, the Alec Baldwin movie shooting, and what maybe some possible consequences of that could be. I actually hadn't thought of this, but I should have. This is a piece from Breitbart. California Democrat pushes gun control on movie sets after Alec Baldwin's fatal shooting. California State Senator Dave Cortese, is it Cortese Pickle? Cortese?
I'm not familiar with him. I can't say.
Okay. Is introducing legislation to ban live guns and ammunition on movie sets in the wake of actor Alec Baldwin's fatal discharge of a prop gun Thursday. Breitbart News reported that 42-year-old cinematographer Helena Hutchins died and 48-year-old director Joel Souza was wounded after Baldwin discharged a prop gun on the set of Rust. On October 22, 2021, Reuters noted that the prop gun Baldwin fired was loaded with live rounds. Hutchins was shot in the chest when the prop gun was discharged. She was transported to a hospital where she was pronounced dead. Fox News observed that Senator Cortese responded to the deadly incident by pushing a new gun control bill to ban live ammunition and guns that can fire such ammunition from theatrical productions across the state. There is an urgent need to address alarming work abuses and safety violations occurring on the set of theatrical productions, including unnecessary high-risk conditions such as the use of live firearms. Actor Brandon Lee was killed on a movie set by a gun firing blanks in 1993. And it goes to talk about Brandon Lee's thing. And then the Hollywood Reporter notes that NBC's The Rookie banned live guns on set following the prop gun discharge by Alec Baldwin. So, where do you guys stand on this? Gun control on the movie sets.
I'm not for it being legislated, but I would say it's probably not a bad idea for the production companies to make their own call on, hey, that's for at least for, live ammo shouldn't be on set just to make sure, they want to have target practice. They want to have other skill training. Okay, offset, off-site, so that way it makes it easier to keep a division of supplies. But I don't like it being legislated.
Okay. Anyone else?
I mean, I look at it this way. Who cares? Now the movie stars are going to have to put up with what we put up with every day, every time something happens in the media. I don't have sympathy for these people. They're asking for it. They're asking for it by their demeanor and by their bending of the knee of gun control when they make their commercials, when they go to these rallies like Matthew McConaughey down there in Texas. They call for it all the time. And now that it's against them, I've seen other actors saying that it's kind of nonsense. It's what we do as our job. Well, so do a lot of trainers. So do a lot of instructors. MK Outdoor Journal is an instructor. He's a range safety officer. So do we. So what's the difference? There is no difference. But the only difference to be had in this case is now it affects their money. When it affects our money, who cares? But when it affects them, now they start to shy away.
Well, go ahead, Squib, if you had something to say.
John Schneider weighed in on this, and he's an actor. He's used prop guns and real guns and blanks and all this other stuff. And I kind of like some of the things he says. I like some of the stuff he's had in his videos, his politics and stuff, but there's some other things just can't get behind the guy on. He says there's no need to have any real guns with blanks on the sets ever again. We can do it all with CGI. I've seen CGI guns. They look like shit, okay? They just do. You can safely use a real firearm with blanks and a blank firing adapter and everything else. It's been done for a long time. There are some accidents, and I think if the actors don't want that, then it should be up to the actors to say, no, I'm not going to star in this film if you're going to use real guns with blanks. or the production company to do that, or like Calaveras said, don't legislate it. However, two things. One, this is a bullshit feel-good law. There's no live ammo on sets. There isn't. This was a screw up. Yeah. Well, there's no reason for it. There's in some places it's not even allowed. Whatever it is, there's no live ammo on sets. They brought it in by mistake. They had this thing loaded by mistake. This was negligence. They took the thing off set, fired it at a range, brought it back loaded. Okay. I'm being very basic. I'm not being very detailed, but that's exactly what happened.
Yeah.
And there are other situations like the Brandon Lee thing where a squib load got him. That was because they took the thing off set, fired it, jammed a bullet down the barrel, and then later used it with blanks without checking it. I think it's up to these companies to come up with better safety protocols or more stringent requirements, to keep them from getting complacent or something else like that. But it shouldn't be up to the government. But this is a feel-good law. This it's like saying, I can't even think of something that already exists that we don't need to legislate, but a politician's going to get up there and I'm going to start the law to say, breathing should be legal. Well, dude, we've been breathing since forever. Okay, so it's just a feel-good measure. This is an absolutely pointless law. It won't change a thing. It won't make it any safer. It won't do anything. But along the same lines, if they get penalized, if OSHA is going in there more often doing inspections, if they have to pay extra fees or have a special safety person there from the state of California, if they're not allowed to make movies in the state of California with blank firing guns or real guns firing blanks or something like that, and they've got to take their business out of state or reconsider how they're going to do the movie or whatever it is, good on them. Let them deal with it. I don't care. For decades, these people have been telling us rules for thee and not for me. We can have these guns. We can have these NFA items. We can do all this stuff. We can glorify their use by the villains. We can glorify their use by the heroes. We can make you like these things, want these things, be interested in these things. But we're going to get on TV every time there's an atrocity and say these are bad, even though we profit off of these. So if there's any law that costs them money, prevents them from being able to make films, especially in the state of California, if there's any law that is going to make it a pain for them, I'm all for it because they need a taste of their own medicine. That's why I have no sympathy for this Baldwin guy. Unlike all the other social justice warriors out there, they're going, we shouldn't be mean. Screw that. Roll Call had it right on his show when he was saying, screw that guy and screw these people. They've been telling everybody that we, the law-abiding citizens who use firearms safely, responsibly, are bad guys, but it's okay for them to do it. And so even if the law is just a feel-good measure, they need a taste of their own medicine, or they deserve a taste of their own medicine. So I just don't care.
Well, I'll back you up here, Squid. See, like when a tragedy happens or some kind of misconduct with a firearm happens out in the population, these people are turning around on the TV talking about gun control. When it happens to them or one of their, I'm doing quotation, air quotes here, one of their people that are in their circle, it's about, oh, we should feel sorry for these people. We should, oh man, oh, this is horrible, terrible. But when it comes down to us as regular gun owners, when some nut job does something stupid, now it's our fault. Now we're the bad people. Now we should have gun control. We're not responsible. Isn't that what Lisa Milano said? We're not responsible enough to have guns. We're not this, we're not that. But when it happens to their own, for their own stupidity, then we have to bend the knee to these people and be like, oh, we're so sorry, Mr. Baldwin. Oh, no, it doesn't work that way. It doesn't work that way with me. Maybe it'll work that way with others, but it doesn't work that way with me at all. You know, what's good for the goose is good for the gander.
Well, this piece from Breitbart by John Nolte has a opinion. Says that banning real guns on movie sets is just stupid. In the wake of Alec Baldwin accidentally shooting and killing a cinematographer last week, there's serious talk of banning functioning guns on all movies and TV sets. All gunfire should be CGI'd now, they say. Well, of course they say that. And we all knew they would the moment the news of this awful event broke. Because that's what they always do. push a panic button, and boss everyone around like a bunch of old women. This is what America has become. An irrational and increasingly stupid country required to overreact to everything. Overreacting is now the only way to prove you care. It's so predictable. Something terrible happens, and rather than blame the individuals involved, the hysterical virtue signalers, mainly the media and politicians, burst out of the woodwork to blame everything, like the system or society, and now everything must change. According to various reports, Helena Hutchins was not killed by a policy, system, society, or even a gun. Her husband is a widower, and her child is motherless because a countless number of people did not do what they were supposed to do. The armorer, the first assistant director, and the movie's star and producer, Alec Baldwin, did not check the gun to be sure it wasn't loaded. Baldwin pointed a functioning gun at another person and almost certainly pulled the trigger. Idiot crew people used the prop gun for real target practice. Idiot crew people mixed actual bullets with blanks. The producers hired these idiots. Thus far, I've counted 15 things that went wrong on that set that led to the tragic death of 42-year-old wife and mother, and not one of those 15 items blames the gun. Nevertheless, when you read the hysteria, you're led to believe the gun pointed itself at poor Hutchins and pulled its own trigger. Nothing about this is funny, but I do find it amusing that when you read a story about how this isn't the first time someone was shot and killed making a movie, the story is always about the 1993 shooting death of Brandon Lee on the set of The Crow. Why? Because that's the last time this happened. In 1993. Let me repeat. 1993. That was 28 years ago. In all of movie and television production, how many rounds do you think have been discharged over 28 years? I'll bet it's in the millions, and until last week, no one had been killed for 28 years. Why? Because the safeguards put in place after Brandon Lee's untimely death not only work, they are foolproof. But you have to follow them. Helena Hutchins is not dead because there was a functioning gun on the movie set. She's dead because cheap producers hired incompetents who handed a loaded gun to an actor who pointed a gun he didn't check at another human being and likely pulled the trigger. But if you go back and read how Brandon Lee died, it was a perfect storm of unlikely events. But if you've been following the Baldwin story, you know this was a deadly shooting just waiting to happen, a perfect storm of incompetence, negligence, recklessness, and a lack of respect for the most basic rules of handling firearms. But this is America in 2021, and we are required to prove how much we care by how much we freak out. So if there's one deadly shooting in 28 years, ban real guns and make movies even more fake with CGI'd muzzle flashes and actors jerking their arms. Oh, and let's put all the armorers out of work, a whole class of specialists. There's no need to have any real guns in movies, they screech. Yes, there is. The CGI looks and feels fake. And there's also the question of free artistic expression. I love the John Wick movies as much as anyone, but the fake muzzle flashes and blood spurts still look fake. And John Wick is a top-shelf production. This all fits in perfectly with how stupid this country's become over the last few years. Bad cop in Minneapolis, burn the whole fucking country down. Virus with a better than 99% survival rate, shut the whole fucking country down. Transsexuals have hurt feelings, let men share locker rooms with your daughter and outlaw jokes. Arrogant schools boards don't like being challenged, have FBI target parents as terrorists. A handful of kids hospitalized, make them all wear masks. What a stupid country we've become. How hard is it to not point a working gun at someone and pull the trigger? Stupid, stupid, stupid. It's all so stupid. I find that I have to agree completely with Mr. Nolte. This is all so stupid. I think Mr. Nolte is absolutely correct. There's absolutely no reason to ban functioning guns on movie sets as long as people actually follow the safety protocols in place. That's the thing. Actually follow the protocols. Don't take a prop gun that's actively being used on a movie set out in the desert and pop off live rounds with it. If you want to be able to have your actors or go out and do some training or whatnot or practice and use live rounds, That's fine. I have no problem with that. Have a separate set of guns for that. Never mix the props for the movie and real stuff together, and you don't have these problems. Don't allow any live rounds on a movie set, and make sure, as a basic bottom line, that the person who is responsible for checking that actually fucking checks it. Follow the procedures. Follow the safety protocols. Follow what you're supposed to do. Simple, folks. Hold the person, the individual who was supposed to have done it and didn't, accountable. This is the same thing that they do with us every time something bad happens. Let's ban it. And it's ridiculous. What do you guys think?
You know, to some extent, that director of photography or whatever, she even has some responsibility in her own death. Now, I'm not giving Al Baldwin a pass or anybody else involved a pass, but I was talking with some people about if we were to do a YouTube video where we were going to use blanks, we're going to use real guns and blanks, and we were going to follow the rules that the actors use, where they point the guns offset and they're 20 feet away and they test the blanks beforehand. They've got to pass a certain thing. I'm going to check your gun and I'm going to show you my gun or let you check my gun before we yell action and we shoot a take. And if we are reloading blanks in between takes or another day passes or whatever, I'm going to check it again and again, because you're pointing a gun in my direction. You might even be pointing it offset, like they point at an angle away. It still doesn't matter. Now, if everybody on the set wants to just trust the armorer, or trust the prop master, or trust the producer or director or whoever, then that's on them. And somebody can go, well, they're not gun experts. Okay, you've got a gun pointed in your general direction as part of your job. You might want to get yourself an effing clue. You might want to get a clue. They have lots of these movies where they send the actors away to boot camp where they get them in shape and they teach them how to handle weapons, and they do some military type stuff. They do exercise. They do all this stuff to try to get them in the mindset to play these characters. And it is nothing to do a one-day training every so often where you're handling real guns and they're explaining all this stuff in a no differently than if everybody on the set had to take first aid training to satisfy the insurance company. A half day or all day of CPR and first aid and stuff. There's nothing to this. So if she's going to let a douchebag like Alec Baldwin point a gun at her and thinking that it's empty and not bother to verify it herself, or the director standing behind her is going to do the same thing, or even the cameraman, that's on them. Now, if they're afraid for their job, they're afraid if they do that, it's going to be a problem, or it's going to take too much time. Like Baldwin was saying, we've been working long hours, it's real stressful. Everybody's got to make a choice at their job what they're willing to do. I do some dangerous things here at my job, and I know at what point I'm going to say, I'm not doing this, or I'm going to walk off. I'll just go find another job. So to even some extent, she bears some responsibility in this negligence. But complacency happens. And because they decided to go cheap, just like a company going cheap on some of its stuff, and then its employees suffer or whatnot, that's exactly what happened. They should be looking at this as a workplace accident. California OSHA should be all over this, really more so than anything else. But I just...
It was in New Mexico, wasn't it?
Or, yeah, I'm sorry, New Mexico. You're right. I drove right through there a couple days after it happened. What am I thinking? So, yeah, New Mexico OSHA should be all over this. But, yeah, I really like what they had to say in this article, Budget. I'm glad you read it. Or Mike, MK. You wear so
Call me
many
what
hats.
you want. It's all good. Just call me what you want. It's all good. No, I think that really what it comes down to, and so much of it, and it's why the left, the Dems, which it doesn't surprise me now that I think about it, are pushing for outlawing of actual guns on the set, is that it comes down to a lack of personal responsibility and a refusal to accept that some personal responsibility would have solved all this. Some personal responsibility on the part of the people whose job it was to ensure that this didn't happen. Some personal responsibility on the part of the production company executives who hired incompetence. Some personal responsibility on the part of the producers who failed to address the safety concerns that the crew had who walked off the set. Some personal responsibility on the part of the production company who hired scab workers to come in. And on and on and on, all the way down the line. It was a series of people, individuals, who failed to exercise their personal responsibility. But we know that there is a portion of the body politic who doesn't want anyone to exercise personal responsibility. So, of course, they're going to blame the gun. They always do. That's how it works. And
you know what?
Go ahead.
I was just saying, you know what I think happened? I think when the people started walking off the set, he started getting all crazy, or it was an instance where he grabbed the gun off the table and he started acting like how he acts in real life, which is a complete ass. And he's like, "Oh, I'll shoot you," and he starts pulling the trigger and it starts shooting people. I think that's what happened. I think that's how that went down.
What I don't know. I haven't heard exactly any details. I don't know if we ever will, but yeah. In other news, there's some good news for us Buckeyes here in Ohio. We talked about a constitutional carry bill that was in committee. Well, a substitute bill, fortunately, has made it out of committee here in Ohio. This piece from the Buckeye Firearms Association from Thursday. House Committee passes HB 227 constitutional carry bill. On Thursday, October 28, 2021, the Ohio House Government Oversight Committee approved substitute House Bill 227 and passed it out of committee on a party line vote of 8-4. If it becomes law, this would make Ohio the 22nd state to allow people to carry a concealed firearm without a license. Pardon me. Specifically, the bill would make licensing optional. Those who still wish to acquire a license can still do so. This provision preserves reciprocity agreements with other states that allow Ohio residents to carry concealed while they travel. For those who do not wish to apply for a CHL, anyone 21 years of age or older may carry as long as they are not otherwise prohibited by law. HB 227 also addresses one of the more confusing aspects of Ohio gun law, the so-called duty to inform. Under current law, a person encountering law enforcement must promptly notify an officer that they are carrying. The word promptly has been interpreted differently by various police agencies and prosecutors, leaving gun owners in a vulnerable position even when they believe they have complied with the law. Ohio is one of only 9 states to put the burden of notification on the person carrying a firearm. HB 227 removes the ambiguity of current law by clarifying that a person must notify an officer only when asked during a stop. The original bill, and this is me digressing, the original bill removed that duty to notify entirely. So this was a compromise that the lawmakers, squishy Republicans, felt they had to make somehow. But I digress. Buckeye Firearms Association has worked extensively with the House Government Oversight Committee, including Chairman Shane Wilkin, to secure the votes necessary to send the bill to the full House for consideration. Similar legislation is being considered in the Ohio Senate. Senate Bill 215, sponsored by Senator Terry Johnson, has received 2 hearings before the Senate Veterans and Public Safety Committee. The best part about HB 227 is its clear-cut simplicity, explained BFA Executive Director Dean Reich. Under HB 227, anywhere you can currently carry with a license, you will be able to carry without one. This clarity should allow for quick approval by the full House. Then it says, contract your Congress elected representatives. Here's another couple changes that they made from the original bill into this substitute bill, of which I am not a fan. Number one, the original bill changed our concealed handgun license to a concealed weapons license. And they took that out. And the third change that they made was that currently in Ohio, the default setting is that a place of worship, you are not allowed to carry a firearm unless you get written permission from the pastor. That was removed, would have been removed from the law, and you would have been able to carry with permission, without permission, whatever, you'd be able to carry. They removed that provision from the bill, so they got rid of it. So the default setting in Ohio would still be that a church or other place of worship is a criminal protection zone. That being said, the watered-down bill even is a step in the right direction. It's still constitutional carry. Is it perfect? No. But as I've said time and time again on this show, is that Hail Mary passes don't often happen. You're not always going to get everything you want. If you only get half of what you want, well, you know what? You still got that half. You can come back later and get it. That's how that is the entire story of concealed carry here in Ohio. Because at first, you weren't allowed to do it. Then we got a absolutely crappy concealed carry bill passed. And over time, well, let's trim that off of this, and let's trim this off of this, and let's trim that off of this. The concealed carry laws in Ohio have gotten better and better, thanks to people like the Buckeye Firearms Association working a little bit here and a little bit there to make crappy into not crappy, then into good, and now trying to make it better. Is it going to be perfect? Absolutely not. Way better than what we have? Absolutely. So I'll still support the bill, even though I'm not happy about some of the changes that they made to the substitute bill. As always, I will keep my ear to the ground on this issue and let you guys know what's going on as soon as I find out. What do you guys think? Should we be telling our Congress critters to not vote for the substitute bill because it isn't as good as we want? Or should we tell them, go ahead and vote for this, and then we'll come back later and try to make it better?
Definitely that. Take what we can get for now, but but they better not stop fighting.
That's my take. I don't know. What do you guys think out in the chat? Particularly any Buckeyes that are out there?
Yeah, I agree with you. I've gotten into this with so many people, especially young people or people that just got into this like yesterday. We got to get it all. We all got to get it now. We got to get it yesterday. We got to do it all, or we got to do nothing. It's like, no. Sit down, son. Listen to an old man talk. This is how you do it. They take a little at a time. We get a little back at a time.
Yep.
It's a back and forth. That's what it's always been. No, we got to get a big. No, it doesn't work like that. You can live in fantasy land and spin your wheels and not make any forward movement, but I'm going to do what works. And somebody can tell me I'm a FUD. I'll say more than I'm a pragmatist. But it's worked. What you were talking about has worked. Here in Michigan, they didn't have a concealed carry law that really worked for everybody. You had to be like a retired cop or own a business. It was difficult for somebody just because to get a permit. And the permits really, the system sucked. So then what they did was they said, county by county can decide. And in some of the counties, they just said, come on in, pay your fee, pass your background check, take your picture, you got a permit. Other ones were like, well, you got to do this and do that. Well, that only worked for so long, and then people were complaining. So they said, all right, statewide, we're going to do this. We're going to take the most lenient county rule and make it statewide. A few years later, they started cutting back on some of the restrictions, and it's gotten better and better and better.
Yep.
And I've said it on your show time and time again. If Ohio or Indiana get constitutional carry, Michigan will do it too, but we will not do it on our own. We will only do it if a neighboring state does it. So I want you guys to get it, not just for freedom, and so that when I come down there, I can constitutionally carry, and because I believe it's the right thing for all states, for the entire country, but I know it will benefit us as well. And it can go the other way, too. If there was some sort of, BS anti-gun law passed in Ohio or Indiana, they might try to copycat it here in Michigan, too. Maybe not so much copycat one in California, although California does tend to, everything that they do tends to spread across the country, unfortunately. And there's nothing we can do. There's nothing we can do about it on this end, except stand up for it when it gets here. And sometimes some states do, and we push back. But the whole thing about it is that I don't think that people are looking at the big picture. They just want the big win. And real life doesn't work like that. It just doesn't. For the people that have been doing this for decades and have seen a lot of stuff, it just doesn't work like that. You want to make a change, you want to make big swings all at once, you're going to have to change a whole lot. And it ain't just you signing up for the GOA and starting up a YouTube channel. It takes a lot more than that. So I would take what we can get because you can build on that. Yep. Because you go back with the evidence years later when they're trying to change it and go, look what's happened since we've gone constitutional carry. Crime rates have gone down or other things like that, right? Or we haven't had a situation where it's the wild, wild west is what they were saying here in our state when they made it where it's shall issue, right? They thought even the governor that was opposed to it said, it's been going on for years and the wild, wild west never happened. So what can I say about it? I can't say anything bad about it. She opposed it, but so that's how you build on these things. I'm glad that you presented it that way. And it'd be nice if a lot more people would understand that instead of just living in fantasy land.
Well, slow progress is still progress. That's how I look at it. Slow progress is still progress. Did I only gain an inch? Well, shit, I'm an inch closer, right? You got to play the long game with this. You got to take the long view. All or nothing usually results in nothing. I mean, in my experience, that's how I see it. Speaking of little progress here, a little progress there, maybe we're going to make a little progress with carrying firearms outside the home being recognized as a right, as it should be, all across the fruited plain, as Rush used to say. Wednesday, oral arguments start in NYSRPA v. Bruin, used to be NYSRPA v. Corlett. From CNN Politics, the two newest Supreme Court justices could redraw the roadmap for the Second Amendment in courts. This is from today. The Supreme Court will hear oral arguments Wednesday in a case that could broaden gun rights nationwide and transform how the Second Amendment is interpreted in the United States. On the surface, the dispute involves whether a New York law that restricts individuals from carrying concealed handguns outside the home for self-defense passes legal muster. The case is brought by two individuals and the New York State Rifle and Pistol Association, which is affiliated with the National Rifle Association. They just had to put that in there, right? So I figured I'd say it in a sinister fashion because that's what they meant. The court's 6 conservative justices could look skeptically at the broad reach of the law and could ultimately make it easier for individuals to carry arms for self-defense outside of the home. But at oral arguments, all eyes will be on the court's 2 newest members, Brett Kavanaugh and Amy Coney Barrett, to see how far they push their colleagues to do something more. As lower courts judges, the 2 Donald Trump nominees signaled that they think courts need to rethink the framework often used to measure how every other gun regulation should be evaluated. If Kavanaugh and Barrett's view of the issue prevails, critics fear the conservative wing of the court will not stop at allowing more people to carry guns in public for self-defense. Instead, the court could junk the legal test that has been used to uphold most gun restrictions in lower courts over the past decade and provide what critics fear will be a roadmap for lower courts to look skeptically at a whole range of other gun laws. What they're talking about is the balancing test that you have to balance whether... anyhow, they go to explain it. Kavanaugh... I just was digressing. Kavanaugh and Barrett, in their previous roles, rejected an approach grounded in balancing an individual's right to bear arms against the government's interest in passing law at issue. Instead, they said judges should focus on the text, history, and tradition, the intent of the founders, in weighing a gun restriction. History is consistent with common sense, Barrett wrote in a 2019 dissent in a case concerning a felon disarmament law. As for Kavanaugh, In a 2011 dissent concerning a ban on semi-automatic weapons, he said he reads Supreme Court precedent to mean that judges should not recalibrate the scope of the Second Amendment right based on a judicial assessment of whether the law advances an important government interest. Instead, they should look to history. He acknowledged that the approach might cause complications when courts are looking at some new gun regulations that relate to a condition that did not exist in the founding. But he stressed the Constitution is an enduring document, and its principles were designed to and do apply to modern conditions. Such an approach that wholly rejects any consideration of the government's interest in the law worries supporters of gun restrictions. Well, no shit, because the Constitution isn't written. Here's the thing that these people fail to grasp, and I'm going on a rant here. They fail to grasp the fact that the Constitution has nothing to do with the government's interest. The Constitution has everything, particularly the Bill of Rights, has everything to do with what the government can't do. It has nothing to do with what the government's interest is. It has to do with the people's interest, not the government's. This is what these people don't want to grasp. This is what these people refuse to grasp. This is what these people know to be true and lie about every damn day. But I digress. Given the significant increase in gun violence around the country, the last thing we need is a decision that would allow lower courts to start striking down strong gun laws simply because they can't find what they think is sufficient support for them hundreds of years ago, said Eric Tershwell, the executive director of Everytown Law. In other words, paid shield for Michael Bloomberg, whose job is to lie about everything because he just lied there. Given the significant increase in gun violence around the country, first off, crime has been dropping steadily for decades. Second, there is no such thing as gun violence. There's just violence. The tool is irrelevant. Supporters of New York's law say that changing the lens through which courts examine gun laws could ultimately lead to courts striking down more restrictions in a variety of areas related to guns. Since the Supreme Court issued a landmark opinion in 2008 holding for the first time that the Second Amendment protects the individual's right to keep and bear arms, and a follow-on decision 2 years later, they're talking about McDonald v. Was it McDonald v. City of Chicago? I think. They're talking about the Heller and McDonald cases. Lower courts have often analyzed gun laws using a two-part test. First, they look to see if the restricted activity is protected by the Second Amendment, and then they apply the appropriate level of scrutiny to analyze the law. If, for example, a restriction goes to the core of the right, it triggers what is called strict scrutiny. Since a law faces an uphill climb, such a law faces an uphill climb. It must be narrowly tailored, and it must serve a compelling government interest. A less exacting standard would be intermediate scrutiny. A law analyzed under that tier has more of a chance to survive because the government has to prove that it is substantially related to an important government interest. Since the Supreme Court has not decided a major Second Amendment case in more than a decade, it has not had the chance to weigh in extensively on the legal tests lower courts should be applying. Because of that, a tiers of scrutiny approach has been utilized, and most restrictions since 2008 have been upheld. This could change soon. In some ways, the methodological question of how the justices need to analyze the Second Amendment rights are equally important, and maybe even more important in terms of the spillover effects of this case for future cases, said Roman Martinez, a Latham and Watkins lawyer who frequently argues before the court. The test that the justices developed to assess the New York statute at issue here will then be used by lower courts to assess the constitutionality of gun restrictions imposed by other states and the federal government, he said, and added, so the stakes are high. When Kavanaugh speaks at oral arguments, he could press his views on using text, history, and tradition to determine whether a restriction should fall. The thinking goes that there hasn't been a history or tradition of imposing a certain type of regulation, then that regulation is basically invalid. In 2011, Kavanaugh made clear how he thought the law should be analyzed. Supreme Court precedent leaves little doubt that courts are to assess gun bans and regulations based on text, history, and tradition, not by balancing tests such as strict or intermediate scrutiny. Kavanaugh wrote in his dissent. He said such a test might actually protect the ability for states and the federal government to impose more restrictions on gun rights. Indeed, governments appear to have more flexibility and power to impose gun regulations under a test based on text, history, and tradition than they would under strict scrutiny, he said. Interestingly, one friend of the court brief filed to the Supreme Court by a judicial conservative in the New York case argued that the law should be upheld and analyzed under an approach that looks to history. The brief was filed on behalf of J. Michael Lutig, a conservative who used to serve on the Fourth U.S. Circuit Court of Appeals. He argues that the New York law at issue can be upheld if evaluated under text, history, and tradition. He said that a constitutional right to bear arms outside the home, in public and in public places, has never been unrestricted and indeed has historically been restricted in many public places. That view does not give comfort to supporters of gun regulations. There is no good reason why gun laws in 21st century America should be tied to or limited by how 18th and 19th century America responded to the threat of muskets in a very different nation, said Jonathan Lowy, chief counsel of the Brady campaign. Lowy believes that courts can look to text, history, and tradition, but they must also consider a government's interest, especially in the context of new weapons in the modern day that addresses new conditions, says the guy writing an article on the website that didn't exist ever in history until recently. If he were maybe writing this with a quill and parchment and having it printed on a movable type printing press, then maybe I might give him some credence on that one. But again, I digress. Writing for a group of law professors, Donald Verrilli, former Solicitor General for the Obama administration, warned that text, history, and tradition don't always speak with one voice, and that a test of whether a law passes constitutional muster thus cannot always depend on how long a law has been on the books. In his brief, he highlighted that a text and history approach could endanger limits on places like airports and planes. It is clear, for example, that airplanes are the kind of sensitive places where legislatures should be able to prohibit weapons, Verrilli argued in briefs in support of New York. However, Congress did not regulate firearms in airplanes until the 1960s, many years after airlines began commercial service. Thus, it is hard to see how a court applying a purely historical text could uphold restriction on weapons in flight. As for Barrett, when she submitted her Senate questionnaire as part of her confirmation process, she listed the 2019 case as one of the most significant that she had decided. She noted that a man named Ricky Cantor was challenging the application of a federal and state felon dispossession law that prevented him, as a nonviolent offender, from owning a firearm. He argued that the laws violated his Second Amendment rights. A panel of the Seventh U.S. Circuit Court of Appeals upheld the application of the law. I dissented, she wrote in the questionnaire. Looking to the founding era history, I explained that legislatures have the power to prohibit dangerous people from possessing guns, but that power extends only to people who are dangerous, not to nonviolent offenders like Mr. Cantor, she said. So, buckle up, folks. This is going to be a very contentious decision, one way or the other. I'm hoping somebody's broadcasting these oral arguments because I'll sit and watch them. That will be interesting. Am I going to make a prediction on how the court's going to rule? There ain't no way. I really hate to say this because I believe in my heart that the Constitution clearly states that we have the right to keep and bear arms anywhere and everywhere. But others don't share that opinion. And, well, I guess it's up to these 9 people in black robes to decide what's right. So, yeah. I'm cautiously optimistic, and maybe optimistic is too strong. I'm cautiously hopeful that they'll follow the law, that they'll follow the Constitution. But, man, Roberts is a toss-up. And really, given that any of the justices really, except maybe Thomas, but in particular the newer justices who have yet to rule on a Second Amendment case, it's a wild card. We don't really know what they're going to do. So, yeah. Let's see what happens, right? Yes, my blood pressure got a little bit high there. Tickus. Hey, you came in a little bit late. moved out of committee. They substituted a bill that took out the change from concealed handgun license to concealed weapon license. They took out the repeal of duty to retreat, not duty to retreat, duty to inform. We'll still have to inform if asked. And they kept in where churches and other places of worship are by default gun-free zones unless you have permission from the pastor. So that's the update on the Ohio constitutional carry bill. Yeah. So, Supreme Court, what do you guys think? Did I lose you?
I don't trust him. I don't trust him one bit.
I knew that was coming.
It's really it's a shot in the dark right now to try to make any kind of predictions on them because there's too many wild cards.
Yeah.
They're either going to wiggle out of this one or they're going to stab us in the back. That's why I keep saying we need a way to be able to petition to have these people removed, their appointments revoked, their pensions taken away. If they're afraid that the citizen can affect their livelihood, can affect their legacy, can affect their ability to abuse their power, they will do what the citizens want. But as long as they are appointed...
Well, and that's the problem, Squib.
Accountable.
That's the problem. They'll do what the citizens want. What if 51% want what's clearly wrong?
No, they're not doing what the citizens want already, okay? And they're not going to. As long as they don't have to be accountable to us, they won't be. So until they're afraid for their jobs, they're not going to be accountable to us. They're going to do what they want, which to include doing nothing. So don't be surprised if they wiggle out of this one.
I'm surprised that New York hasn't tried to moot the case by granting the two complainants concealed carry licenses. I'm really shocked that New York hasn't tried to moot it yet. Maybe they will over the weekend.
I mean, the simple fix for this
Monday.
If this has the chance of moving something forward that's positive, that's great. I don't think it'll happen. And I'm not worried about them. I'm not as much worried about risking losing more from this. I'm really not, even though there is some potential there. But at the end of the day, these two people in New York, if they wanted to set a precedent, probably moving out of New York would probably be a lot more effective. But, let's just see where this goes. But I have a feeling it's just going to go nowhere.
We'll see. We'll see. I think that they're going to make a ruling, and I think it's going to be favorable towards the Second Amendment. I know I said I wasn't going to make a prediction, but okay, here goes. I think they're going to rule in favor of the Second Amendment, but I think that Roberts is going to try to make it as absolutely narrow as he possibly can. I think that's what's going to happen, because I think that by the Constitution, they can't avoid it. By precedent set in Heller and McDonald, they can't avoid it. But I think that Roberts...
They've avoided everything now. What's the difference?
That's because they haven't heard anything up till now. They've been avoiding it by not hearing it, but this they're actually hearing. So far, fingers crossed, hearing it on Wednesday. Assuming they do hear these oral arguments, and assuming that New York doesn't act within the next few days to moot the case, if they actually hear unmooted oral arguments on this, I think they have no choice but to rule in favor of the Second Amendment. But I think the only question is, how much? Is it going to be really narrow? I think that's what Roberts is going to try to do, is make the ruling as narrow as possible. We are not going to get, I really doubt, and I hope I'm wrong, but I really doubt we're going to get sweeping all across the land shall issue. I don't think we're going to get that. New York might, but the rest of the country, I don't think. I don't think we're going to get a different, I don't think they're going to eliminate the balancing test. I just don't think they're going to. we'll see. I hope I'm wrong, but I think it's going to be a limited victory for us. That's my prediction there. Let's finish up the main topics with something that's just really damn cool. We talked about last week the Marine who snatched the firearm from the would-be robbers and pummeled one to the ground while another fled like the roach that he is. He held the boy there until the police came. Well, we gave him the Balls of Steel Award last week, and apparently the Yuma County Sheriffs did too. Yuma County Sheriff presents former Marine who disarmed robber with Valor Award from October 26th. On Tuesday, October 26, 2021, the Yuma County Sheriff's Office hosted a recognition ceremony for Yuma resident James Kreitzer, who disarmed a suspect during a recent attempted armed robbery. First off, I'm going to digress. Those of you who can see this picture, look what the man's wearing. MAGA hat and Let's Go Brandon t-shirt. That's awesome. According to the Sheriff's Office on Wednesday, October 20th, 2021, at approximately 4:30 a.m., deputies responded to an armed robbery report at the Chevron located at 10747 South Fortuna Road. Upon arrival, deputies learned that 3 suspects entered the Chevron, one of them armed with a handgun. As the armed suspect walked by Kreitzer while pointing the weapon at the cashier, Kreitzer reacted without hesitation, quickly disarming the suspect and taking him to the ground. He was able to immediately gain control of the gun and detain the suspect until deputies arrived. As a result, no victims were injured and no property loss was sustained. Sheriff Leon Wilmot presented Kreitzer with the YCSO Citizens Valor Award for extraordinary heroism and exceptional courage while voluntarily coming to the aid of another citizen during an incident involving criminal activity at extreme, life-threatening personal risk in an attempt to save or protect human life. The YCSO Citizens Valor Award is the highest award for citizens whose actions warrant a recognition. The American Legion Post 19, Marine Corps League Territorial Detachment 635, Chevron General Manager, and the Yuma community were also in attendance to award Kreitzer with tokens of appreciation. Out fucking standing. So good for him. Or at least I think so.
Yeah, that's for he certainly took his life into his own hands on that one, but he did a damn good job, and kind of epic the way he was dressed when he came time for his award.
I think that's the best, not the best thing about it, but it's damn sure an awesome thing about it. Do you other two fellows have a opinion on this? Squib, what do you think of your fellow Marines' actions?
I mean, yesterday, another Marine here and I were commenting to one of the employees that we were going to go down to a convenience store and look for some trouble, kind of, show off too. But no, I think that's good. And he's exercising his rights that he served to protect, not just for himself, but for everybody. So I think that's a good way to be a good citizen, to be a good patriot. No matter what, the fact that he's exercising his freedom of expression while accepting this, and without people like him, there wouldn't be that freedom.
Absolutely right. I can't agree more. So, I think that it's just, this whole thing is just awesome. And, I can't say how pleased I am that the Yuma County Sheriff's Office had the good sense and intelligence to recognize this devil dog's bravery. Unfortunately, though, the people in our next segment can't exercise such good sense and intelligence.
And now prepare yourself for another tale of stupidity in this episode of Moron of the Week.
So coming up here in Moron of the Week, let's see, let me change this. First off, we have this wonderful Tennessee Congressman, Steve Cohen. This is a piece from The Truth About Guns by Dan Zimmerman. Tennessee Congressman Steve Cohen is a lying liar who lies about defensive gun uses. Who are you going to believe, me or your lying eyes? That is, in effect, the narrative relentlessly pushed by the anti-gun rights left in this country. That's nothing new, of course, but after 18 months of blistering gun sales and rising violent crime, the firearm prohibitionists, their media stenographers, and the politicians who share the goal of civilian disarmament are getting a little panicky. Take, for instance, this recent assertion by Tennessee Representative Steve Cohen, a member of the House Judiciary Committee. This is a tweet. It says, in case you missed it, Representative Cohen just said that he'd never seen a case where a good guy with a gun stopped a bad guy with a gun. Countless Americans who've had their lives saved by the Second Amendment would disagree. Let's go ahead and listen to what this fool has to say.
Show me a case, please. We didn't have them in Memphis, where a good man or woman with a gun protected and stopped the use of a weapon. That canard doesn't occur. That just dog won't hunt.
That just dog won't hunt. He says, show me a case. Please. We didn't have them in Memphis. So, whoever's not unmuted, please mute up. Show me a case, please. We didn't have them in Memphis, where a good man or woman with a gun protected and stopped the use of a weapon. That canard doesn't occur. That just dog won't hunt. I couldn't find who Cohen was addressing that remark to. He was probably talking in reference to the employee who went postal in a Memphis post office earlier this month, but it really doesn't matter. To be clear, Representative Cohen is lying. He isn't simply ignorant or misinformed. He didn't misspeak, and he wasn't misunderstood. He's lying his ass off in order to support the narrative that civilian gun ownership represents an unalloyed evil in society that benefits no one. We have a feature here called Defensive Gun Use of the Day, and, as you guys will see in a little bit, I have a feature called Self-Defense Shoutouts that chronicles scores of instances every year in which gun-owning individuals use their Second Amendment rights to defend themselves and their families. The Centers for Disease Control, surely an institution the Congressman trusts, at least since January, recognizes studies that have found defensive gun uses happen anywhere between 60,000 and 2.5 million times a year, depending on who's doing the counting. Some will claim, of course, that the congressman was actually talking about citizens using guns to stop mass shootings. You know, that whole Wayne LaPierre good guy with a gun thing that drives the hoplophobic Harridans so insane. We're sorry to burst the congressman's well-insulated, beltway-bound bubble, but surely even he heard about the shooting at the West Freeway Church of Christ outside of Fort Worth that was stopped by a congregant with a pistol. It was caught on video for all the world to see. But that was almost 2 years ago. Someone as busy and important as a U.S. congressman can't be expected to remember something like that. Okay, then. Let's jump in the Wayback Machine and go all the way back to last week. That's when an employee of a grain elevator in Nebraska who was armed with a shotgun stopped a workplace shooting after a man who had been fired earlier that day opened fire. CNN even reported it, so it must be true. Could someone as intelligent, erudite, and informed as the distinguished congressman possibly be so woefully ignorant of the tens of thousands, millions, of times each year that Americans use guns in this country to defend themselves against assault, robbery, rape, and murder? Spoiler alert, he isn't. No. Instead, Representative Cohen simply can't allow himself to acknowledge the good that the civilian firearms ownership represents in this country. To do so would undermine his agenda and piss off some of his most loyal supporters in the civilian disarmament industrial complex. Lord knows he can't let that happen. Instead, Cohen spouts plainly false, easily refuted garbage like he did in the video above. He'd rather expose himself to ridicule from those on the other side of the political spectrum and then label it fake news, white supremacy, or right-wing insurrectionism than antagonize his funders and those who keep him in office. In other words, it's politics. Better to spout a lie and look the fool than acknowledge an inconvenient truth. And so it goes. Did one of you have something to say to this?
No, sorry, that's where my button got bumped turning my mic on by accident.
Oh, okay. Well, next up, our next contestant in Moron of the Week are these wonderful U.S. Marshals. This is from 2fab.com from 10/27/21. U.S. Marshals hold mom and baby at gunpoint after raiding wrong apartment. The young mother said the U.S. Marshal's office told her to get over it and take a melatonin. U.S. Marshals looking for a murder suspect raided the wrong Florida apartment last week, terrifying a young mother and her baby at gunpoint, video shows. Kata Staples said she and her 3-month-old daughter were fast asleep when 2 armed men knocked on her door, according to a TikTok video she shared on Saturday. When the U.S. Marshals show up to your house and rush you and your newborn baby out, running all through your home, telling you they know you are lying and you're hiding someone in there just to find out they're at the wrong apartment, she wrote alongside the Ring clips. We were taking a nap and my Ring doorbell kept alerting me that there was motion detected, she explained. When I clicked on it, there were 2 men standing there in bulletproof vests with guns pointing at my door. After one of the marshals yells for Staples to open the door in the video, the young mother can be heard telling him that she is trying to put her dog in the kennel. And even though she repeatedly says no one else is in the apartment, the other marshal says, "Tell him to come out with his hands up. We know he's in there. The place is surrounded." Staples said that when she cracked open the door and the armed men pushed her and her baby out of the way, per WFLA, "They're holding us at gunpoint, screaming. There's a gun about the foot away from her face," she told the outlet, adding that the marshals insisted, "We know Shamar is in there." "With that, they run in my apartment," she continued. "There's probably 6 or 7 of them out there with guns. 3 or 4 of them run into my apartment and are running around. They're still yelling at me that I'm lying." Staples said one of the officers eventually realized that they had the wrong apartment, informed the others, and led the group out of her apartment and down the hallway to another one. In her Ring videos, Staples could be seen crying in the hallway while telling the marshals, "You guys came to the wrong apartment." The man the marshals were searching for, Shamar Johnson, who was wanted for a September homicide, was found moments later in an apartment on Staples' floor, according to a statement from the federal law enforcement agency on Tuesday. The statement also said Staples' apartment was not a target of the investigation. Team members did not make entry, which is an absolute lie, and had Staples not made contact with the team through the Ring doorbell, the team would not have had any contact with anyone in her unit. Yeah, right. The statement did not include an apology, nor did any of the marshals apologize to Staples for their actions or mistake at the time, according to her account to WFLA. As she was having trouble sleeping after the terrifying incident, Staples said she called the U.S. Marshal's office seeking the help from a mental health professional for anxiety. Staples claims a man on the phone told her to get over it and take melatonin. Let's watch this video.
Shield. Matt's supposed to be bringing the shield.
Hello?
U.S. Marshal, come to the door.
I'm putting my dog in his cage.
All right. Tell him to come out with his hands up. We know he's in there. The place is surrounded.
Nobody in
out
here. Okay, hold on. I'm coming. Nina, stop. Oh my God.
We got contact. They got a ring. They know we're out here.
I'm coming.
We got a shield coming or what? Come on out. Come on out.
No.
Tell him to come out. Shamar, U.S. Marshals, come to the door. Put your hands up.
No, I don't even know what Shamar. My husband's been. No, my baby, oh my God.
All right.
You're good.
So I have, aside, even if I didn't have video of this to look at here, I would believe this 100% because I have been the victim of this exact thing. I was taking a nap one fine afternoon because I worked midnights. My dog started raising all kinds of holy hell, and I heard someone screaming. Fortunately, I had my dogs in their kennel, and my wife had left to go run an errand, and she'd left the front door open, kind of half open, and my screen was shut. But I hear a lot of yelling, and I hear my dogs hollering and barking. So I'm like, oh shit, someone's in the house. So I grab a pistol and I go walking out, and I'm looking around a corner with my gun down at my side, and I see a stack of guys with M4s pointed at me, yelling and screaming for me to get on the ground. And this is when I found out that having guns pointed at me does nothing more than piss me off, because I told them to get the fuck out of my house. And they're starting to yell, U.S. Marshals, U.S. Marshals. And I see that they got plate carriers with police. And I'm like, what the fuck are you doing here? Then they start screaming, yeah, we want this guy. We want this guy. And I'm like, there's nobody like that here. What the hell are you talking about? Get the fuck out of my house. I was pissed. At that point, I dropped the gun already because I didn't want to get shot. And they're like, come out with your hands up. So I put my hands up and I start walking. I'm like, listen, I don't know this fucking guy. You got the wrong place. Get the fuck out of my house. Well, isn't this blah, blah, blah? I was like, no, that's next door, asshole. So they scurried off and went next door and got the guy they were looking for. So I believe that I would, even if I didn't have video to watch, I'd have believed this completely because I've experienced it. So who do you guys think deserves the title of Moron of the Week? Is it Corny Cohen, Messed Up Marshals, or Joe Biden just for being Joe Biden?
Marshals.
Well, go ahead and vote in the poll because the poll's out there. Let us know out in the chat at what your vote was that you cast in the poll. Which nobody's voted in so far. But you think Marshals? What about you, Ro?
10-4.
The Marshals.
Squib?
The Marshals. Fire all of them, take away their pensions, everybody who was involved in the sting, take their supervisor, demote him down to lowest level, tell him he's lucky to have a job, give them all the opportunity to voluntarily quit if they think that'll help their chances in the future as opposed to being terminated. I don't care. They worked for us. They screwed up big time. They should pay the price like we pay the price in the private sector.
Yep. So far, we got 6 votes, 67% for the Marshals, 33% for Joe Biden. We've got 10 people out there watching now. Let's get some votes in here, folks. Who do you think should be Moron of the Week? The Corny Cohen for his lies about defensive gun uses, the Messed Up Marshals for going to the wrong house and terrifying that woman and her baby, or Joe Biden just for being President Sniffy? Right now, Messed Up Marshals are definitely pulling ahead. 71% with 7 votes. Messed Up Marshals. 29% Joe Biden. Alrighty, folks, I think we're going to go ahead and call this one for the Messed Up Marshals. You are the morons of the week.
And there we had another tale of stupidity in this week's episode of Moron of the Week.
And so, with that, we go from the ridiculous to the sublime we go to Roll Call 219's favorite segment, Self-Defense Shoutouts.
Yay!
Self-defense shoutouts are not where I'm reveling in the prospect that the bad guy won the room temperature challenge by taking a dirt nap. It is, in fact, where I revel in the prospect that, despite what Senator Cohen falsely claims, the good guy had the means, method, and opportunity to keep the bad guy from making him do the same. First up is this piece in BearingArms.com by Cam Edwards from October 28th. Armed citizens thwart separate attacks in Ohio town. In two separate attempted crimes just hours apart, armed citizens in Trotwood, Ohio, were apparently able to protect themselves on Wednesday night and Thursday morning. It was about 9:15 last evening when the police got a call about a shooting in an apartment complex. Officers arrived and found a man with non-life-threatening gunshot wounds laying in the parking lot, a man described by authorities on the scene as being uncooperative with police. As it turns out, there was probably a good reason why the man didn't want to talk to cops. He was violating a protective order when he was shot. It was just a few hours later when police received another call of a shooting involving a homeowner just a few miles from where an earlier defensive gun use had taken place. A man was killed after he fired shots at the resident of a house on Blairfield Place Thursday morning. Trotwood police responded to the shooting around 1:45 a.m. in the 800 block of Blairfield. The scene investigation revealed the deceased male fired a gun at the resident. The resident returned fire, hitting the deceased multiple times, Trotwood Sergeant Kim DeLang said in a statement. Dispatch records indicated the homeowner reported shooting a suspect who broke into their apartment. Now, Trotwood, Ohio isn't exactly a booming metropolis. It's a pretty sleepy suburb of Dayton that's home to about 24,000 people. If defensive gun uses were really as uncommon as gun control activists and lying-ass senators claim, or representatives, or whatever the hell he is, claim they are, you certainly wouldn't expect to see two cases within a few hours and miles of each other. And yet, here we are. It's also worth noting that many local media outlets are downplaying or ignoring the fact that these were armed citizens acting in self-defense. The Dayton Daily News described the incidents as simply shootings, never using the word self-defense at all. Perhaps that will change as more details emerge in these cases, but it's pretty clear from the initial reporting in both incidents that the individual who was shot was the aggressor. I'm not going to go ahead and go for the rest of the article, but you get the picture. Next up, from AL.com, suspected burglar shot dead during Selma home invasion, from October 28th. A suspected burglar was killed Wednesday night in Selma. Dallas County District Attorney Michael Jackson said the home invasion happened at about 10:45 p.m. at Minter Terrace Apartments on Minter Avenue. The slain suspect's name has not yet been released. Jackson said the occupant of the apartment will not be charged, but any co-conspirator of the slain suspects could face charges. One of the consequences of breaking into somebody's home or business is that you may be shot and killed, the district attorney said. That is apparently what happened here. Citizens have the right to use deadly force if someone is breaking into the home. So, good for him. And good for the homeowner who, of course, didn't do this because, Congress critter Cohen said that it doesn't happen. This must be fake news. WKRN.com. Body found at East Nashville gas station after carjacking attempt identified as 19-year-old, from October 28th. Nashville, Tennessee. Officials have identified the body found at an East Nashville quick-sack following a carjacking attempt earlier this week. The body has been positively identified as Keyshawn Vaughn, 19, of Nashville. Vaughn was found dead Wednesday up against a fence line near the convenience store. His death is connected to an attempted carjacking that occurred Tuesday night in that same parking lot. That night, a 28-year-old man left his car running in the parking lot, which is damn stupid, don't ever do that, only to return and find Jaden Webb, 20, sitting in the driver's seat. The carjacking victim confronted Webb, who attempted to drive away, dragging the victim, who was hanging onto the driver's side door. Webb crashed into the stolen SUV in which he had arrived at the convenience store. Vaughn got out of the SUV and, according to the victim, started kicking him as he was holding Webb at gunpoint. The victim fired one shot at Vaughn, who then ran across the parking lot on foot. Vaughn's death is still under investigation. Let's see, what is the next one? And last but most certainly not least is from PhillyVoice.com from October 26th. Man fatally shot during attempt to confront ex-girlfriend in Northeast Philly, police say. The homeowner opened fire after his door was broken from its hinges, according to investigators. Northeast Philadelphia homeowner shot and killed a man who broke down the home's door in an attempt to reach his former girlfriend, police said. The incident happened around 11:30 p.m. Monday on the 1800 block of Sanger Street, where police found a 34-year-old man who had been shot multiple times in the chest. The man was found outside the home. According to investigators, the man went to the home to find his ex-girlfriend and became agitated when he couldn't get into the residence. The man kicked at the wooden door repeatedly and shouted for several minutes before the door broke from its hinges, police said. The homeowner fired multiple gunshots that struck and killed the man, police said. The homeowner had a license to carry his weapon and was not arrested Monday night. The man who was killed was not armed, police said. His ex-girlfriend was not at the property at the time of the shooting, but arrived a short time later. An investigation into the shooting remains ongoing. I don't give a crap if the guy was unarmed or not. If you're kicking someone's door off its hinges and you bust into their house, you deserve to spring some leaks. Well, folks, that is it. We are done with everything I have to talk about tonight. I want to thank my illustrious and esteemed panel for being here. Squib, is there anything you would like to leave us with? Anything you would like to say, sir?
Yeah, a couple things. There won't be a Caliber Corner tomorrow morning, so everybody can sleep in. Instead of being on the panel for that, tomorrow morning I think I'm going to go ahead and tune into Small Caliber Arms Review. He just dropped a video tonight, A Tale of Two Schofields, so that ought to be interesting.
Oh, yeah.
Also, go to Roll Call 219's channel and check out his rants and raves for this week. I mean, it's a good show every week, but I really liked it this week. If I remember later, I'll go into the comment section for this video and put the link for it in the comment section. But pretty good show this week. So go ahead and check out those two channels. And thanks for tuning in to the Right of the People this week.
Roll call. Is there anything you'd like to leave us with, sir?
Oh, man, go check out my stuff over there on YouTube. You can find me on Instagram. I no longer have a Facebook, so you can't reach me there. I got rid of it. I don't want to be part of the metaverse. I'm on TikTok. I haven't posted a ton of gun-related content on that platform. It is highly restricted. Yeah, they'll kill it real quick. But there is some funny clips in there and some other stuff on that platform as well. And of course, and again, you can just find me over here on YouTube and check out Mike's show. And I have a show on Wednesday nights, 9:30, 10-ish, whenever my internet wants to work. Rants and raves. We're going up to 200, and then we're going to stop. So don't miss these final episodes of the epics of Rants and Raves. So thanks for having me.
That sucks. I like that show too. Last but not least, we have the Tactical Pickle Calaveras 32 Special. Is there anything you'd like to leave us with, sir?
Nothing special. Just, thanks for having me on. And, yeah, that's where I apologize for the feedback earlier. That's where I didn't realize my mic had gotten unmuted, and I was trying to listen into one of your videos that you were playing because it doesn't come through my phone. But I'll try to be better about that next time.
It's okay. It happens. What would the right of the people be without some sort of technical difficulty? Good, maybe, right? Speaking of thanks, I want to thank all of you out there in the chat who were here. Whether you're still here or not, you at least spent some time with us on this Friday night. And as always, I'm humbled and amazed that happened. After you're done here, go check out Foul Territory on the Gizzard Gary channel. He always has a good show, so go give him a listen. But in between now and then, particularly if you live in the Buckeye State and you want constitutional carry to pass, contact your Congress critters and elected representatives. Let them know what you think. Send them a snail mail, email, telephone, telegraph, carrier pigeons, bicycle messengers, smoke signals. heliograph everything that you can do to let them know, and never, ever, ever give up the fight. I'll see you guys on the next one.